So welcome to the plenary panel from the American Constitution Society, Moving Forward in the States and Cities. I'm actually delighted to see this panel be a plenary panel at ACS for one main reason, which is that I think that progressive lawyers and academics have long had an unduly nationalist focus. Now that may be actually because we all went to law schools where we learned civil procedure, which is in fact, of course, the federal rules of civil procedure, where we learned constitutional law, which was, of course, United States constitutional law. It may also be that progressives have long had one dominant narrative about our cause, and that is Brown v. Board of Education. And of course, Brown v. Board of Education is a story about the triumph of a national majority over an oppressive local majority. Or it may simply be that liberals and progressives have long had a nationalist focus because for many decades we enjoyed the luxury of congressional dominance. Needless to say, things have changed. Almost all of the action on progressive causes is now taking place at the local and the state level. It is states and localities, not the federal government, that have done the most to protect the rights of gays and lesbians. Localities have been at the center of resistance to intrusions on our civil liberties, most notably the United States Patriot Act. Most of the work nowadays on environmental reform, universal health care, you name it, is being made at the state level and not at the national level. And in fact, if you look at the work of progressive lawyers for the last 2 decades, a good deal of it has been trying to protect local innovation, work by local governments, against federal intrusion. And if you need one example of that, just think about the last case handed down at the Supreme Court's term this year, which was the desegregation cases. So one might, of course, be a little bit cynical about liberals' new love of the local. My good friend and Federal Society winner of the Paul Bator Award, Ernie Young, called it rather sarcastically, "Welcome to the dark side." I am delighted to be welcomed to the dark side because I am happy to fight about our ideals at whatever level we need to fight about them. And I actually think that the local level is a pretty good place for fighting about our ideals. It's actually not a bad terrain. So as we listen to the stories today of some of the fights about our ideals that are going on at the local level, I hope you'll keep a few things in mind about the terrain on which we are fighting. So there's lots of reasons that you might actually value what's going on at the local level. One is it's arguably closer to the people. So there's some hope that the needs and interests of people will bubble up from bottom up. The second is actually localities and local government allows for quite a bit of variation in who decides. This, of course, has long been the insight of the scholars of federalism. Now, that, of course, has actually long been the worry of liberals, right? So we were worried about a global minority, the supporters of Jim Crow, who were in control of a local minority in parts of the United States. But I think that's the wrong way to think about it, because there are all sorts of global minorities who can constitute global majorities, and there are global minorities that actually liberals care a good deal about. So I think, for example, of racial minorities or dissenters on certain issues. So we should think not just about Jim Crow, but about the Richmond City Council, the African-American dominated city council that created a minority set-aside that was struck down by the United States Supreme Court. Or we should think about San Francisco's decision to issue licenses to same-sex couples, I should note, with the help and assistance of Dennis Herrera. That also was an example of people with an outlier view trying to put their vision into practice. So we should think not only about federalism, but states and local government as a means of letting us take turns in deciding what's going on in our country. Another reason we might value the local is actually it gives us a pretty good farm team. I think this has actually been one of the smartest things that the conservatives have done, which is to recognize that localities and states are a pretty good place for training our next national leaders. They're actually a pretty good place for building support and energy around a movement. And again, just to use an example, if you think about where most of the anti-discrimination ordinances and gay marriage protections are going on, they're all going on at the state and local level. People are using cities like, for example, Colorado, like Boulder and Denver, to build support around a particular idea of gay rights. I think we should value states and localities actually because they make dissent visible in a different way. So when we think about just the conventional vision of dissent, That vision is mostly about making arguments in the abstract. So when we think about dissenters, we imagine them writing editorials in the newspaper, making speeches, engaging in marches and protests. But I actually think you can see dissent taking place at the local level, except dissent is taking place in the form of a decision. And to me, that makes a big difference. It makes a big difference that Massachusetts has given us a real-life instantiation of what a universal health care system is going to look like. It seems to me it makes a big difference that San Francisco, in issuing licenses to same-sex couples, actually showed us what gay marriage is going to look like. It's an answer to the critics. It's an answer to the slippery slope arguments. It's an answer to the power of inertia to actually do something rather than merely talk about it. So all of these are reasons to think that it's a good idea to have localities taking part in the national conversation about our identity, in the national conversation about what ACS is calling a just future. And so I'm delighted to see ACS is actually providing a forum for that conversation today. So let me do two administrative things before we move on to our panel. First of all, I'll try to do my best flight attendant imitation. This panel has been approved for New York CLE credit. If you're interested in obtaining CLE credit, please be sure to sign in. I'll do at the CLE table located by the ballroom doors. Second, because this is a plenary session, we're going to do the Q&A a little bit differently. So I understand that there will be note cards passed out around to you at your table. And if you have a question, then you should find the lovely ACS volunteers with the pink ribbons, is that correct? Who will then sort the questions, bring them up to me, and I will magically pick the very best and smartest ones and ask them of the panel on your behalf. Finally, I should just note that before I introduce the panelists, that there's a reason why I'm the moderator of this panel. It is not because I've written some in this area or because I've been a little bit involved in work in this area. The truth is I'm just a vicious moderator. So one of the things I do as a vicious moderator is I enforce time strictly, and the second thing I do is I engage in a form of shaming. This is yellow for a reason. If you see me hold up this sign, it means that one of these people has gone on too long. So I will hold up this sign. I will give them a 2-minute warning and a nice yellow card to tell them when time is up. So I'm actually delighted to have such a distinguished group of panelists. If I spent all the time telling about you about their resumes, we would never have any time for talking. So let me just give you a brief glimpse into the people who are in front of you. Moving from my left is Mark Dan, who's the Ohio Attorney General, and actually a very new Attorney General since he began his term in 2007. Previously, he was a member of the Liberty Local Schools Board and the Ohio Senate. He's done work on fixing Ohio's school funding system, trying to make college affordable, and protecting local school districts from state funding cuts. Next, I have Jamie, I almost missed you. State Senator Jamie Raskin. I just love calling him Senator Raskin because Jamie is a member of my academic tribe. He's an election law scholar when he doesn't put on his magic cape and become a state senator. He's a professor of constitutional law at American University's Washington College, and he's also the Democratic state senator in Maryland. So he's not only written books, including the best-selling Overruling Democracy, but he actually managed to win the Democratic primary, beating out a 32-year incumbent, and then won 99% of the vote in the general election. That sort of made me wonder, is there really democracy in Maryland? Who wins 99% of the vote? And also, Jamie was able to see 9 bills passed of his own in the legislative session, including a law defending consumers and tenants, and the famous National Popular Vote Act, which is, as you know, an effort by states to try to fix the problems with the Electoral College without actually passing a constitutional amendment. To his left is Linda Singer, who's a District of Columbia Attorney General. Prior to being named Attorney General, she served for 13 years as the Executive Director of Appleseed, which is a nonprofit organization dedicated to building a just society. She was also a staff attorney in the Criminal Defense Division of the Legal Aid Society. And here's another number that I found just shocking, where she handled thousands of cases in trial court and where she lodged a 100% acquittal record, which is no mean accomplishment. Next, we have Rita McNeil, who's the city solicitor for the city of Cincinnati. Previously to that, she was the director of law for the city of Dayton. She served as the second section chief for the civil rights section for the Office of the Attorney General, a juvenile referee magistrate in the Franklin County Courts, chief legal counsel for the Ohio Department of Conscience, and an assistant deputy legal counsel for George Voinovich. Next is Dennis Herrera, who, as I mentioned before, has played a major role in defending gay rights because Gavin Newsom may have issued the licenses, but Dennis Herrera defended his ability to do so in the courts in California. Dennis Herrera was elected city attorney in 2001 in San Francisco. He's actually famous not only for this litigation, but for his affirmative litigation group, which is a group that is designed to essentially pursue the interests and needs of the cities of San Francisco through affirmative litigation tactics. His office has actually made a national reputation for itself, not only in the fight for marriage equality for gays and lesbian couples, but also in efforts to strike down federal restrictions on abortion rights. And finally, excuse me, Representative Raj Goyal, excuse me, I have a little bit of a cold, who's a member of the Kansas House of Representatives. He's the first term, also a newbie, in the 87th District in the Kansas House of Representatives, and he serves on the Tax, Judiciary, and Veterans Homeland Security Committees. He's also a lecturer, another person with an academic hat, at Wichita State University, and also a private attorney. So with that, I'm actually delighted to turn the stage over to Mark Dan and let him tell you a little bit about what's been going on in Ohio.
That's great. Thank you very much. As a minority member of the state Senate last year, I can tell you that I had my microphone turned off by better than you. The best part of taking this job was when I got to sit down with the Senate President, who would frequently gavel me down or turn off my microphone and remind him that I'm now his lawyer, which is kind of fun. I also want to thank everybody here for not expelling Bill Marshall, our new Solicitor General, after he won his first case for Ohio in the U.S. Supreme Court in an opinion written by Clarence Thomas and joined by all of our other favorite justices. So thank you for your kindness to him in this. And I'm very honored to have him as our Attorney General, our Solicitor General, because, in fact, he understands what I think a lot of us need to understand. The last panel certainly was filled with some bad news. I think we have a lot of good news to share about what's going on at the local level, and that the opportunity to improve the quality of life for people in this country, to fight for the values and the goals that we've all fought for in our careers, really is now being fought at the local level. And I think for a long time, we, as enemies of federalism and conservatives as champions, that right now that federalism that the conservatives fought for so hard has become something more. It's become a backstop for overreaching and more often under-regulation by the federal government, preemption without regulation, creating an environment where businesses are literally without any oversight. And the mirror image of that, and the reason why it's essential that state attorneys general not allow themselves to fall victim to this deregulatory steamroller, is the image of our state citizens not being properly protected by the government. Those protections are gone. And those protections apply not just to citizens and consumers and victims of price fixing and victims of civil rights violations, but also to the ethical businesses, the ethical and the honest folks that are doing business in our states and in our country. When there's no regulation, the cheaters get an advantage over those who follow the rules. And it puts us, I think, very much on the side of not just the right philosophy, but also of the right, doing the right thing. And the work that my colleagues and I, including Linda, across the nation do to counteract federal action or inaction is helping to ensure that our state citizens are protected from irresponsible businesses and individuals who would harm our citizens financially, environmentally, or physically. Remembering that the people of this state always bring me back to the reasons why I love this job. Because I ran for Attorney General not to just represent institutions of state government, but to remember that my job is to represent the people that those institutions were created to serve. And what you've seen over the past 6 years is a very dramatic shift, a conscious effort by the federal government to abandon its responsibility to enforce antitrust laws, securities regulation, trade regulation, consumer protection laws, drug regulations, and banking laws. And in response, we've made a conscious decision in our office to mount a comprehensive and aggressive effort to protect and defend consumers, individual and institutional investors, taxpayers, and the ethical businesses across Ohio. And with the help of Linda and other attorneys general from around the country, protect the people and the businesses of the nation. The problem, if you're running an honest and ethical company that's committed to playing by the rules, is that the referees, like the SEC and the Federal Trade Commission and the Justice Department, who were supposed to enforce the rules, have literally checked out of the game. And my level of concern grew as I spoke to other business people, particularly small business people, who told me that the current purposeful and systematic dismantling of the federal regulatory framework that had protected Americans and brought order to the marketplace for 100 years was creating an environment that not only encouraged but rewarded cheating. And by failing to protect consumers and small businesses or actively harming their interests, the federal government has made it necessary for state attorneys general, in particular, to step in and provide whatever length of protection it can for their citizens. This spring, for example, my office authored an amicus brief in the Telabs case, joined by 23 other attorneys general, to urge the Supreme Court to allow investors to get cases into court if there was a strong inference of fraud. The federal government, through the solicitor's office, however, urged that an investor would need to show that in light of all possible inferences, that the strongest inference suggested fraud. Even this Supreme Court rejected that standard. And now there's another case coming along in which the federal government again failed to protect investors' rights, despite a request by the SEC's conservative chairman, Chris Cox, to file a brief on behalf of investors in the pending Stone Ridge case. A few weeks ago, I saw the importance of the Stone Ridge case right in front of me. A lawyer from a Big Four accounting firm, KPMG, told a federal judge, when asked to compare the role of his firm in helping Fannie Mae bilk investors out of billions of dollars, he compared it to a bank robbery. He said his company could hire the thieves, supply the guns, drive the getaway cars, and not be liable because they didn't actually rob the bank. They are, he admitted, guilty but not accountable. And although he acknowledged this may not be good public policy, in parts of this country, it's the law. That's why I joined the Republican Attorney General of Texas to organize 32 attorneys general to file a brief in support of the investors in Stone Ridge. At stake is the question of whether there is any accountability for those who intend to deceive investors through their actions but believe they're free of liability simply because they themselves made statements on which investors relied. It's more than investors. We've looked at other kinds of other areas in business regulation, in bringing environmental cases where the EPA has simply walked away from their responsibilities. The predatory lending arena is one place where we focused a lot of our attention because there's a very significant issue. What we have are the forces of Wall Street, the greatest capital markets in the world, focusing their efforts on a process which resulted in homeowners on one end being screwed and bondholders on the other, all in the name of generating profits for investment banks and bond rating agencies and lawyers and accountants along the way. And if those folks aren't held accountable, then where are we going to force these folks to do what they were sent to, or they should be doing on Wall Street, which is creating capital to create jobs and to create commerce in this country? I had a lot more to say, but I am truly afraid of the moderator. So I will wait and add it in as we go forward.
Thank you. Jamie?
Thank you, Heather. It's great to be here with ACS, which did not exist when I was in law school, and now it's hard to imagine law schools without it. And it's great to be here with this very distinguished panel, and especially my dear friend Linda Singer, who is an attorney general who lives and works in Washington, D.C., who does not suffer from chronic strategic amnesia. And so it's great that you have that title in Washington, Linda. I know that this is, by definition, a nonpartisan affair, but I wanted to start by invoking our last great Republican president, Abraham Lincoln, who spoke of government of the people, by the people, and for the people. At the national level, even with the last elections, we've got government of, by, and for the corporate political action committees, the military-industrial complex, and right-wing religious zealots who think that global warming is a fiction brought to you by the same people who invented evolution. And that's what's going on at the national level. And so Justice Brandeis said that the states were the laboratories of democracy, but the states are also the last refuge of democracy, and they are the place where democracy ultimately will be reborn in America. So, you know, in the last congressional election, the Democrats said that they had 6 items for 06, and only one of the 6 has been adopted by Congress, which was the minimum wage increase, which went to $5.85 on Friday. Now, in my state, in Maryland, the minimum wage is $6.15. In a lot of states, the federal increase basically meant nothing because the minimum wage was already higher. We also adopted living wage legislation in this session, which requires that contractors with the state who get contracts worth $100,000 or more pay a living wage to their workers. And in urban areas, that means $11.30, and in the rural counties, $8.50. And so the principle is a simple one, which is that states should not be complicit in paying people poverty wages and reinforcing the dynamics of poverty. If you go to work every day, maybe you shouldn't necessarily earn as much as an investment banker or a hedge fund owner, but you should at least be able to feed your family without being on food stamps. And so we did this in Maryland. A number of counties and cities have adopted a living wage. And if you think about it, the gap between a living wage and the minimum wage is a gap of shame for our society, because it's saying that it's all right for some people to earn enough money to keep them in poverty and to keep their families in poverty. I am a freshman senator on the Maryland Senate's Judiciary Committee, and I was thinking if I were on the U.S. Senate Judiciary Committee, I would have spent the last year fighting with Attorney General Gonzalez about documents and statements and so on. We actually got a lot of work done. For example, with my colleague, Sandy Rosenberg, who's a delegate in the Maryland House of Delegates, we introduced legislation to deal with the Fourth Circuit Court of Appeals, which is, I think, the most rancid and reactionary federal judicial circuit in the country, which has made it virtually impossible for successful civil rights litigants to hang on to their verdicts on appeal. And we introduced a statewide civil rights anti-discrimination law, which allows people to go into state court with a private right of action and the right to jury trial, that was passed in 2007 for the first time, so that going to federal court in the Fourth Circuit is now not the only option for people who are suffering job discrimination. I was at a conference recently with a judge who's on the Fourth Circuit, and I, as tactfully as I can, which isn't very tactfully, I raised the issue of the record of the Fourth Circuit on these civil rights cases, and I said, isn't there a real problem with your jurisprudence regarding race discrimination? And his answer was, well, we apply the same strict standards not just to race discrimination, but to sex discrimination and disability discrimination and so on. And I thought about the great story about Sidney Morgenbesser, the philosopher at Columbia University, who was subpoenaed for jury duty, and he was in the jury pool in the veneer, and the judge said during the voir dire process, Professor Morgenbesser, it's a case about police brutality. Before we put you on the jury, we want to make sure that you haven't had any experience with the police that was unpleasant or unfair. And he said, well, actually, I had an experience with the police that was unpleasant, but it wasn't unfair. And the judge said, really, what happened? He said, well, I was going to this civil rights rally in Central Park, and these two police officers came and started beating me over the head with their billy clubs. And the judge said, well, that's terrible, but why do you say it was unpleasant but wasn't unfair? And he said, well, when they were beating me up, it hurt a lot, so it was unpleasant, but they were doing it to everybody, so it wasn't unfair. And so anyway, I told him that story. It didn't move him very much, but we've got our own law in Maryland now. We have good housing legislation, again, despite the fact that the federal government is doing nothing on housing right now. We passed very good condo conversion legislation to give tenants a right for 180 days to know about a condo conversion, to try to put the financing together, the right for elderly and disabled people to stay in their apartment units for a 5-year period on a rental basis if they can't afford to buy. Ex-felon voting, we re-enfranchised 120,000 people in the state. I got to be the floor leader, and I promise I'll stop with this story, but I got to be the floor leader on this fight about ex-felon voting, and the other side of the aisle got up and said, the Democrats, they want to re-enfranchise murderers and rapists and robbers and traitors to the country and so on and so forth. And so I got the signal, okay, it's time for me to get up and respond to this. So I said, well, the vast majority of people who are going to get out of prison, unlike murderers who are going to be in prison for life or subject to the death penalty in our state, the vast majority of people are convicted of nonviolent offenses, not violent offenses. And let's take one of them, one of my constituents who's just gone off to prison in Western Maryland, Jack Abramoff. If anybody should be disenfranchised for life, certainly it's Mr. Abramoff, who committed sins against the polity itself through corruption, and yet we believe even in the possibility of redemption and reform for him. So we were also able to get through the National Popular Vote Bill, which we can talk about perhaps in the Q&A on reforming the Electoral College. So I do urge all of you young people in law school to think about the states and the counties and cities as a place to go with a group of friends and to really begin to move a progressive agenda that can begin to move the whole country back to where we should be going.
Linda?
Well, I have to say I would have never expected to find myself in local government. I grew up in the South and came of age in the 70s, where my formative source of information about local government was probably the Dukes of Hazzard and the whole boss hog thing. And, your vision of local government was incompetent, corrupt, and kind of mercifully irrelevant, given all of that. But I think we've seen, as you've heard from the other speakers, and as you all well know, that over that same formative time period, the federal government has become gridlocked, polarized, and largely left the stage on so many issues that matter to particularly urban America. And speaking as the Attorney General of probably the only purely urban jurisdiction, we feel it deeply. And on issues of healthcare, the environment, crime, you name it, it's really the states and local governments where the issues are being played out. So I wanted to start by talking about one issue that's unique to the District of Columbia. And we have a unique vantage point, I think, on all of these issues, being that we're a company town where our principal politics and policy. We're also a city and a state. And Jamie knows this issue well because he wrote about it in a formative law review article, which is the fact we're the only nation's capital in the world that is not represented in our national legislature. It is an enormous injustice. Congress has to approve our budget, our laws. We went through an experience this winter where the mayor and city council agreed to take over the city schools, and we went through 3 holds in Congress, the last of which was by a senator aggrieved by our taxi meter system. So here you have 60,000 district residents being held hostage to somebody who's annoyed by their fare from National Airport as they head home every weekend. So as we pay our taxes and send our residents off to fight in a war in which we had no voice in authorizing, it's an issue of deep, deep importance. And I want to thank Jamie for his leadership on that issue. We have kind of a ironic relationship with the Constitution sometimes in the District of Columbia, because while we don't get Article 1, it seems, about voting representation, we seem to have won a contest with the Second Amendment. And one of the big cases, which I know you all are probably aware of, is a case called Parker versus the District of Columbia, which challenges our 35-year-old ban on handguns. It's an issue that is of enormous importance to us, too. When I came to the district 15 years ago, we were known as the murder capital of the country, and we will not go back there. We've had 1,200 homicides since 2000. 70 of those are children. 81% of those homicides were committed with guns. So right now there's an enormously important debate that will happen, we expect, in the Supreme Court. We are getting ready to file a cert petition this September. We expect the court will take the case. It will be its first Second Amendment case since the 1930s. The D.C. Circuit, which ruled on this case below, held for the first time in the nation's history that there is an individual right to bear arms under the Second Amendment, unconnected to militia service. The Supreme Court will have a chance to look at that issue. We believe that not only is the Second Amendment not a constraint on the states and cities that are doing what they need to know to keep their residents safe, but that our law is reasonable, because it's, again, designed to keep people safe. But it's not an academic issue. It's not, the subject of just law school classes for us. It really is a life and death issue for the residents of the District of Columbia and so many cities. I also want to talk about what our office does, and I think each of our roles is very different. The District of Columbia Attorney's General Office has both city and state functions. Am I getting the sign? All right. There are 350 statutory duties we have. With only 2 minutes left, I was going to read them all, but I'll just skip over that. We do the abuse and neglect system. We handle child support cases, commercial transactions for the district. We do the legislative work. We're the juvenile prosecutor, and we do civil enforcement. And it's really those kinds of issues that I think Mark was talking about, where I think we play an especially important role, which is enforcing our environmental, consumer, labor, healthcare, all of those different laws. I want to give you an example of some of the things we're doing, which I think are really at the cutting edge both of lawmaking and of legal jurisprudence. We're investigating anti-competitive practices, antitrust violations that we think have raised the price of AIDS drugs in this country and kept people from getting the care they need. We're investigating how an insurance company has worked with how their contracts with hospitals and doctors have increased health care prices and kept people out of the health care system. We're defending two very far-reaching district laws that regulate the increase in prescription drug prices and require disclosure about relationships in that system. And it's really on healthcare and on so many other issues that the states and the cities are taking the lead right now. It was Massachusetts litigation that ended up in the Supreme Court this year that's forcing the government to write rules relating to global warming and what we're going to do to stop that. On tobacco, and I think you can't talk about the roles of the attorneys general without talking about tobacco, because it's not the FDA that stepped in to regulate tobacco. It was the states that put the first real restrictions on how these children. On predatory lending, which I know Mark talked about, it's the states that are leading the way to figure out how we rein in these corrupt business practices. We are close to the ground. We are able to move fairly quickly, and I, having come from the nonprofit world to government, have to define this as relative. But certainly compared to the federal government, we move with lightning speed. We work, I think, less ideologically, and though I think probably most of us on this panel would agree, and certainly those in the audience, you know, there's no ideology about trash collection or public safety or those issues. You're there to serve people and get them what they need. And that's ultimately, I think, what makes our work meaningful and rewarding. We deliver services that affect the day-to-day life of the people who depend on us. We make them safer, we keep them healthier, we help them prosper. And that's the work that's being done in the cities and states right now. Thank you. Rita?
Well, it is certainly a pleasure for me to be here as well, and as Linda articulated, this is a very different panel. I serve as the city solicitor for the city of Cincinnati, and I am certainly honored to be on a panel with our Ohio Attorney General. And it is an exciting time for us in the state of Ohio, especially because of our Attorney General. In case you did not know, Cincinnati and the state of Ohio tends to be a conservative region. We have the proud honor of carrying Bush in the last election, for which many people will hit us upside the head for. But we are proud of it. No, I'm just kidding. But I'm from Chicago, and every time I go home, I hear about it every time. When are you moving? When are you moving? But in Ohio, we're starting to do some new, exciting things. We initiated some gun litigation some years ago, and as they say, timing is everything, and it was not good timing. But that's how Dennis and I became very familiar with each other, because we tried to do something to protect our communities. In our local communities, in our cities, we have this thing called home rule. And inherent in home rule is the ability to control and protect your community and use your laws to do so. And slowly but surely, preemption has stepped in to stop us, to say you really don't have the right to protect your community, or you're not going to be able to use your laws to protect your community. And we have said, no, I don't think so, but we've had to be more creative in doing so. So we recently initiated lead paint litigation, which the Attorney General has taken up for us, and so we don't have to take that fight on alone, but the Attorney General is taking it on part of the state of Ohio and saying that we are trying to look out for our children and for our communities, and that the paint manufacturers need to step up to the plate. And there are many that are saying, no, they really don't. You need to prove it beyond a reasonable doubt or clear and convincing evidence. And we're saying, no, it's there. It's, as we say in law school, res ipsa loquitur, the thing speaks for itself. And so there is a group out there that needs protection, and we have a responsibility to do so. But in being creative, in the city of Cincinnati, in 2001, we had civil unrest. And when you are faced with what some call civil unrest and some call riots, you have to figure out, what are we going to do to protect our communities? What are we going to do differently that we don't want to put it in the hands of the courts? Because if you put it in the hands of the courts, they're just going to say, especially in a conservative community, police do what you do and citizens just obey. Well, that doesn't really work very well when you've got a real schism and disconnect between your community and your police. So we decided to do something different, which is the first time it had ever been done in the country, and that was we entered into a collaborative agreement. We also had the memorandum of agreement, which many people are familiar with the Department of Justice, and that gave you what you expected, the rules and guidelines by which you must operate. But the collaborative said that we as a city, we as a police department, the court system, the community, the citizens, and it involved the ACLU will join together to make Cincinnati a better place. This was the third riot in years in the city of Cincinnati, and that says to you, unless you're asleep, that there is a problem. And so you can't leave it in the hands of the court, so we entered into this agreement. And as a result of this agreement, we are working to bridge the gap which obviously exists between the community and police. We created an alternative dispute resolution process where if one wants to file a 1983 civil rights violation case, they would first file in the ADR process and say, we think that our rights were violated, we think we were profiled, and then it gives us an opportunity to change it, to change the nature of the community without having to go to the courts where they'll issue an edict. But I will challenge the senator to say, if you think the Fourth Circuit is bad, the Sixth Circuit is sometimes much worse in protecting the citizens and the community. And so we had a global settlement, which we were able to settle a multitude of cases for the benefit of a large group of people who felt that their constitutional rights had been violated either by search and seizure or profiling. But we also wanted to economically empower our community. And Cincinnati is trying to grow, as many of the other cities are, economically and trying to create the growth and vibrancy within their community. And in doing so, we have built a new football stadium, a new baseball stadium, an underground railroad freedom center, a new convention center, and we've done a multitude of housing projects. And it was interesting that we talked about the Croson case as part of the Richmond case as part of the introduction, because that limits our ability to allow others to get a piece of the pie. And through that, it's become difficult to allow minorities and women businesses to have goals within the project. So we said, how can we do this differently? How can we invite everybody to have a piece of the pie? And what we did was we created an SBE program. Well, I have to be honest and say we created an SBE program with some ambitious goals. We called them goals. The court didn't quite agree with us and said that they called it pretty much a disguise for what was really an MBE, WBE program. And it would
actually not speak quite so much in code for the
minority business enterprise or women business enterprise. And we said, no, it's not a disguise. Well, he basically said, you need to remove every indication of race and gender from your policies and procedures as you try to set forth goals for these construction projects. And we said it would be simple to say, okay, fine, then we can't do anything. But instead, we decided to take a different approach and use our home rule power and empowerment to do something different. And so what we did was we created outreach programs. We created clear goals that are goals based upon small business enterprises without any reference to race or gender. We also had a leadership commitment. Leadership commitment meant that we were making sure that the project was monitored, making sure that contractors set forth goals for their small business contracting. And we also made sure that there was active participation by all parties within the project. And then we continued and pursued communication so that there was outreach. If it's a matter of being a small business enterprise and you need to be a disadvantaged business enterprise to get a piece of that pie for federal dollars, then we were getting small businesses certified as disadvantaged business enterprises. So the key, I think, is it is a good time. It's an exciting time. But for us, you have to be creative. Because if you leave it in the hands of the courts or you leave it in the hands of the federal government, the reality is it won't be done. So it's really changing your picture frame and finding a different way to come to what you want to do to protect your communities and empower them in the way you need to. And I miss not getting the yellow sheet.
Exactly. Well done. Dennis?
I'm just going to lead off by saying I love the Ninth Circuit. I've got no problem with that. Okay, I love the Ninth Circuit. I can't help but say, as I've been sitting here listening to everybody and focusing on what the panel was going to be about, to sort of be drawn back to some of the discussions that happened yesterday at the plenary panel in the morning, and then the backlash breakout panel, because I think it's really instructive to where we're sitting here today. If many of you remember during the Race and Constitutional panel in the morning, Professor Liu and Representative Davis and Ted Shaw were engaging in a fairly healthy discussion with Judges Wilkinson and Barquette with respect to the limits on each branch of the federal government and its ability to respond, as well as are decisions sort of made in a vacuum, or how do we reach out and make sure that society is comfortable with where we are going. And I think it speaks volumes that here we are focusing on what we're doing at state and local level to get out there and push the agenda, and really push the agenda and with demonstrable results. And that comes back to where we were at in the breakout panel yesterday, when there was some discussion about, here's Massachusetts with Goodrich. That now, Goodrich is the law in Massachusetts, and they can't even get 50 votes to put it on the, to get a constitutional amendment vote in 2008 to repeal the ability of the right to marry in Massachusetts. In Massachusetts as well, you also have universal health care. Massachusetts has been out there pushing the agenda and setting the agenda in a way that the federal government has not. And I think that what you find here is that we're representative of the same tradition. And when you look back to 1983, when President Reagan in his State of the Union address unveiled his new federalism initiative, and everybody went crazy thinking it was signifying a retreat from the federal government's commitment to progressive social policy, which it was, no one knew what a great opportunity that was going to be for us at the state and local level. And I think 25 years later, we are still in the dawn of that era, because it takes a long time to change people's attitudes. But great work has already been done and is only a harbinger of what can come in the future. So I don't think we've come over to the dark side. I think we're the new Federalists. I think that's what we are as we move forward. But I think it's important to recognize that we're not taking steps simply to make a statement. It's important that we can articulate a legitimate state or local interest when we move forward. Now, I think that might be a little bit counterintuitive coming from San Francisco, where everybody thinks we get involved in everything under the sun. But I can sit here and document for you that we have a legitimate state, local interest in virtually everything that we have done, whether it be by me in my office or whether it be my brethren in the other avenues of government, whether it be our universal health plan that's passed here in San Francisco that is now in the courts, whether it be our Sunshine Ordinance or our equal benefits and domestic partner legislation that's become a model across the country. San Francisco could articulate a legitimate local interest that we think has driven the agenda and now is being replicated in other places across the country. With same-sex marriage, certainly it asserts our long-held principle that discrimination is detrimental not just to the minority that is being discriminated against, but also to the majority that would abide it. But I recognize that some people think that's not enough. Well, we went out and asked our city controller during the course of our litigation, how much is this costing us in dollars? And we documented $20 million in cost annually that we could put to that, whether it be as a public benefits provider with public assistance to health care that we provide to folks that are together but aren't married, whether it be tax delinquency rates, which we can demonstrate without the benefit of two legally obligated adults responsible to each other, drastically increase. I'm proud that we were the only municipality to stand by Planned Parenthood and intervene in a late-term abortion case that was recently heard by the Supreme Court. And we have a tangible interest in that as well, because I am the lawyer that advises our largest public hospital, San Francisco General Hospital, which is a healthcare provider of last resort to underserved women throughout the Bay Area in terms of reproductive services and counseling advice. They need to know what the state of the law is. So we have legitimate interest in that as well. But I recognize that there are other things that are perhaps less controversial to people where we can really make a difference. The Brookings Institution recently documented that San Francisco has the second highest concentration of payday lending institutions in the country that are unfortunately, some of them exploiting lower middle class and economically at-risk individuals. So we recently filed a lawsuit in the name of the people of the state of California, which I have the ability to do, charging at least two of these companies with charging interest rates that would make a loan shark blush, and through affiliated relationships with out-of-state banks and online relationships have gone out and really exploited folks to the nth degree. And it's just not something that we are going to tolerate. I will say this. A couple of years ago, I was very happy that we filed a litigation called our E-rate case, which was a key TAM action that San Francisco filed, which demonstrated that there were a couple of technology providers that were defrauding the federal government's E-rate program. That is a program that was designed to help urban and poor school districts bridge the digital divide. We found out that information. We shared it with the federal government. I testified before Congress on it, and we recouped $30 million to the federal government, as well as stopping the practice and helping urban and poor school districts nationwide. So that brings us back to where we started, and that is we have a great opportunity. And I recognize that the political environment of San Francisco is unique. And not everybody is going to have the ability to go out and push a same-sex marriage case, or a late-term abortion case, or perhaps one of the other economic cases that I've articulated. But the fact of the matter is that they should have the ability if they want to, and if that's in their community's interest. And that is what is going to drive the national agenda, to have people be responsive and responsible, and that will drive the agenda at the national level as well.
Great, thank you.
Well, this is wonderful. I'm glad I'm going at the end. I have a slightly different perspective on what happened in the states. First, a geography lesson. Kansas is a rectangular state located in the Midwest of the country. You often fly over it, I know, and we'd love to have you stop more often and see us in Kansas. But it really is an honor to be here with this panel, and I'm very thankful to ACS for not only putting this panel, but for, at least with me up here, reaching into Red America and to deep into the Midwest, into the Plains, to get a slightly different perspective on what happens at the state and local level. Before I was actually in the legislature, I was, I suppose, one of you. I was at the Center for American Progress, one of the first employees there, and returned back home to my district where I grew up and beat a three-term incumbent whose party shall remain nameless, and in a district that is overwhelmingly of the other side. And so that was part of, I think, a wave in 2006, not part of the national wave, actually, but part of something that I think is unique to what's happening in what's called Red America that I really want to talk about, and it's a little different than the great advances that you heard from the others. What we do in the legislature, from my experience so far, just to give you a little bit of the context, of 125 members in the House, only 47 members in my caucus. We are a few votes short of having veto override capability on the other side. So the way that we enact progress is by not regressing. And so I just want to give you a few examples of sort of what we spend our time doing. In particular, I'm glad we have the voting rights experts on the panel. We had a bill in the legislature that was presumed to go through, and that my leadership actually advised me I shouldn't fight because the governor could just veto it. The bill would have required a passport or a birth certificate to register to vote, in addition to extreme photo ID requirements. It was the worst voting rights bill in the nation. We beat that. I went down, thundered against it, marshaled some resources. We beat it by one vote. And the reason I give that example is that doesn't make the front page of the New York Times. What makes the front page of the New York Times is our conservative state school board talking about, as Jamie so nicely pointed out, views on evolution that have subsequently been reversed, I might add, but other examples of how things are happening in not a progressive manner. But that was an enormous victory in the State House, because it kept a very bad touchstone from being formed. All of you would have known about that bill had that actually gotten through the legislature and had to be presented to the governor, or if we didn't have a governor of our persuasion, would have actually been signed into law. And so that's just one example of how we, again, have to beat back bad things to lay the groundwork for good things. We also had a piece of legislation that would have denied all public benefits to undocumented people in Kansas. All public benefits. It was a very badly written law, and I think some of that was the reason why it was defeated. But we also beat that by a very slim majority. And although many states have actually, you've read, proposed many bills related to immigration, we seem to have quite a tendency from some of our friends in western Kansas, where there's an incredibly large Hispanic population that's rising, to be quite reactionary. So we actually have to beat back, again, bad bills to lay the groundwork for moving forward. Before I got in the legislature, we had an enormous fight, similar to Maryland, over the funding of our public schools. And in 11 hot days and a special session in 2005, beat back a myriad of constitutional amendments that essentially would have stripped much of the power from the Kansas Supreme Court, would have changed the appointment process, and again, only by the slim that beaten back. It was interesting hearing the discussion about the minimum wage. In Kansas, we do have a minimum wage. It's the lowest of any state that, except for the states that have no minimum wage, it's less than $3. We actually had 50 votes on the other side to even abolish that. So, in point of fact, our discussion is really not in the place of enacting living wages. It's preserving what we have and, again, laying the groundwork. Now, how are we laying the groundwork? As you know, I hesitate to ever use the word sexy in politics, but Kansas got a little bit of sex appeal last year with the book, What's the Matter with Kansas? I hope, at least for the 87th District, we know what's right with Kansas now, but we are moving forward in Kansas because of the split that is happening on the other side. And so these political forces that are at play, and again, Kansas, especially in the 19th century, was certainly at the forefront of what was happening nationally in certain trends. And so the way that we succeed is by forging coalitions with moderates of the other party, and by essentially there being a wedge on the other side. The good thing is that we're not the ones who have to actually cause this wedge. They're busy fighting themselves and killing each other without really a lot of our help. But that moderate progressive coalition is forming, and it's the reason why I'm able to be elected in what should be a hostile district. It's why our governor, Kathleen Sebelius, has been able to be reelected. It's why Paul Morrison beat Phil Klein, who was arguably the most hostile to progressive values attorney general in the state of Kansas, and he did it at 65% of the vote. What that indicates is that there is a coalition forming, and it is a deep hunger for common sense government. And that's not, that's not flashy, and it's not exactly it's not on the forefront of some of the great efforts that my colleagues have been able to talk about. But it's very important, and I liked what Mark said. He said it's a backstop for overreaching. And I think that is what common sense government is about, is that we are now developing and seeing that a majority of Kansans are sick and tired of the extreme social division, the emphasis on the things that divide us, and badly want things that unite us, and to stop the ideological wars so that we can actually enact some things to move forward. My final point I want to make is about the progressive infrastructure. As I said, I worked at CAP, and the way that I beat that voting rights bill is I called my friend Justin Levitt at the Brennan Center on his cell phone. I said, Justin, I don't really read anymore because now I'm a state legislator. I need you to read for me, and so can you please put some talking points in my mouth and tell me, is this bad? Because I think it is. I used to know if it was, but please tell me. Justin calls me right back and says, yep, Rod, it's the worst. I was then able to go down to the floor of the House and say, this is the worst piece of legislation. And it's certified by a voting rights expert, and he had conveniently just had an op-ed in the Washington Post legislator's desk. Now, I shouldn't have had to have his cell phone and my BlackBerry to get him because he's a personal friend, but it's an example of how the progressive infrastructure, which ACS is so instrumental in, which CAP is part of, which all of you are part of and support, is beginning to work. And so my final point is for all of you who are law students, Jamie made this plug as well, it's great to go back to your states, but if you are in a place that is more hostile to progressive values, you must go back. It is the most important thing you can do. The work being done here is absolutely vital and it's absolutely important, but just as you've heard, the innovation is happening. I guarantee you can win in places that you never thought you would with a lot of hard work and knocking a lot of doors. I hit 10,000. I know Jamie hit a lot. All you do is have to go out and say, I want to work hard to bring people together for common sense reasons. You'd be shocked at what you can find. So please come to Kansas and Red America.
Thank you very much. So I actually want to first start by talking to you. There's been quite a good amount of variation in the way that you describe what you're doing. So some of you talk about lawmaking and pushing things forward. Others talk about progressing by not regressing, or being the backstop against overreaching, to use Mark's phrase. So I wonder if you might be able to just tell me a little bit about how you think about the war you're fighting. Is it an offensive battle or a defensive one? And is that because of the politics of where you are? Or is that because you're using law as a tool, and law is basically sort of an inertial tool that doesn't really move us forward very much? Mark, do you want to start?
Well, I think that one of the things we've got to get better at, and I think we've done a good job of in the first few months in my term, is in framing what we're doing. When we talk about the progressive things that we're doing, when we talk about taking on predatory lenders, or we brought 57 environmental cases in the first 7 months as compared to 6 in the first 7 months for the last 2 attorneys general that held the office. We talk about it in terms of law enforcement, in terms of the fact that we are punishing the cheaters so that the ethical businesses can go on and do business. I think we're kind of in the position now, because I think at some point we got a little bit arrogant and overreaching in our rhetoric as well as in our actions, 20 years ago, when we were kind of in control of Congress and in control of the things that we were doing. And in the same way that the conservatives in my state kind of put themselves in that position, and they lost, I think, I think as Raj was talking about, the middle, the center of the public's view of how things ought to be done. And so we are the mainstream folks now. We believe in law and order. We believe that polluters ought to be punished, and those that don't pollute ought to be rewarded. Those are the kinds of things, and framing in a right and wrong kind of context is very, very important. People rip off people, steal their homes and their dreams of home ownership in order to enrich themselves on Wall Street are bad. Those that create capital to invest in fuel cells are good. I think those are really easy arguments to make and to talk about. And so a lot of this is in doing the right thing and then doing it and describing it and talking about it in the context where people in your state are comfortable.
Anyone else want to jump in on this?
I think that I look at it, I have a great luxury in that I come from a jurisdiction that I do. It makes life really easy and wonderful, and I come from an office that has a tradition of being involved on the cutting edge of issues anyway. My predecessor was heavily involved in the tobacco litigation, and I carried on that mantra with stuff that we have done on guns and obviously same-sex marriage, abortion, you name it. But it's very easy to get that support in a jurisdiction to move forward. But by the same token, since oftentimes what we do in San Francisco, even in California, is under a tremendous microscope, it has to be framed in the right way and in a measured way and in a way that is really based on the law and the facts and doesn't come off as too shrill or too histrionic. And I'm very proud of the fact that we have such a dedicated group of professional lawyers, some of whom are here, that really carry that out. And I think a good measure of that is the fact that recently in the California legislature, I had there was a bill that I was sponsoring which would continue my ability to do the good affirmative work that we do, even if our population goes below 750,000 at the time of the next census. It was at risk of me losing that ability. We pushed that bill. People said I would never get Republican support. It passed the legislature, and it was signed by Governor Schwarzenegger. I took that as a tremendous compliment, and it was editorialized by a lot of different people that, you know what, the city attorney's office has fought the public battle in a responsible way. They haven't overstepped, and they're fighting the battles that we, not just here in San Francisco, but as Californians, want them to fight. By the same token, I also use that to push some things on the law and order side, which some people in this room probably wouldn't really support. But we have a public safety crisis and gang activity in San Francisco, and I'm pushing a gang injunction program in San Francisco that a lot of people don't like, and I've agreed to disagree with folks on that. But I think that that's an important thing. So I think that if you have the confidence and people think you're going forward to do what you believe is right and you're principled and articulating right, you're going to get that support.
Jamie?
The wonderful thing about the separation of powers horizontally and vertically is that there's always political space in society for the people to be pushing a progressive agenda. So you're always playing offense and defense at the same time, depending on what field you're playing on. Just quickly on the national popular vote thing, there have been repeated efforts to abolish the Electoral College and to go to that very radical idea of the winner of the national popular vote actually becoming president. That's always commanded strong majorities in the U.S. House and the U.S. Senate, but never the two-thirds majorities required and then the three-quarters of the states. So the National Popular Vote Plan that we passed in Maryland, it was signed into law by the governor, says that we're forming an interstate compact with other states that will join us, that we will agree to cast our Electoral College votes for whoever is the winner of the national popular vote. So, elections like 2000 would not happen again where you have the national popular vote loser becoming president because of the Electoral College system. And, we will begin to cast our electors that way when we get enough states representing 270 in the Electoral College. It's passed in a whole bunch of states, including California, although it was vetoed by Governor Schwarzenegger, passed in Hawaii, although it was vetoed by the governor there. But certainly if we see another election where the Electoral College is used as an opportunity for strategic partisan mischief, I think that we will see an insurrection, at least among what we call the spectator states, that is the two-thirds of the states that are safely red or safely blue, where there's no presidential election campaign, where we are flown over in search of the votes in Florida or Ohio, with all due deference to Ohio, and the handful of other states that are still swing states. So again, that's something that is bubbling up all over the country now, whereas you couldn't move that in Congress.
If I could briefly, I just would say, in terms of the offense-defense question, I like the points about credibility. Because we have credibility established now on our side of the aisle on defense against regressive things, we can now be offensive on other issues like renewable energy. We are now framing that in a progressive way. It's important. Kansas is a very windy state. We have no trees, and it's flat. And so, every Kansan instinctively gets, we could be good at this thing. And so, we are able to put that in a progressive framework that says this is about good jobs, about being good stewards of the earth, and about really economic development. And it's only because we have the credibility by stopping bad things on the other issues. Now, ideally, down the line, in the future, we can start playing offense on those other core issues, but for now, we have to pick our battles.
Just to add, we all come from wherever we are. The needle starts where it is in each of our jurisdictions. But the thing that has amazed me is just how much muscle there is in state and local government. The office I oversee has 725 staff, and subpoena power, and just an enormous ability to move whatever issue we take on. So you are where you are. The question is what you can do with it, and this is a platform that really does matter.
So here's a question. Whenever I present a paper on the values associated with localism, there's question 1A and 1B. And as I'm going through this pile, they almost all fall into the category of 1A or 1B. So 1A says, look, this is all fine and good when you're talking about San Francisco or some city that we liberal academics like. On the other hand, if we're going to license liberal jurisdictions to do good in the world, aren't we also licensing conservative jurisdictions to do what people on my side of the spectrum would think of as bad things in the world? So if we're licensing people to sort of do the right thing in schools, aren't we also going to license them to stop teaching evolution in the schools? How do you deal with that in a principled way? And then question 1B is the backlash argument, which I'll look to Dennis at this moment. So the story is, it's all well and good for a place like San Francisco to start issuing licenses to same-sex couples willy-nilly. On the other hand, the rest of the country hasn't quite caught up to San Francisco, and so goes the dark story of backlash, which I don't buy, but nonetheless, so goes the dark story, and so therefore the Democrats lose the national election, or, sorry, not the Democrats, liberals lose ground on gay rights issues. So I sort of wonder how you deal with these question 1A, 1B. Is there a principled defense of localism that doesn't involve licensing people to do things that we actually would want to fight them on? And two, are we worried about letting people engage in what's called agenda setting by political scientists when the agenda setters are actually a little bit out of step with the rest of the country and might put things on the agenda too quickly? So I'm happy to let whoever would like to start. I'll let Dennis start on it since I tweaked him.
Well, I would say this. Let's just look at, I mean, to me, that's a false choice that people posit oftentimes about, oh, well, let's think about the backlash. Okay, well, let's look at the backlash. Let's use same-sex marriage as an example. I didn't see any backlash in Massachusetts. Now people accept it for what it is, and it's moving forward. There's progress being made in other states, obviously incrementally. In New Jersey, people said, that was right before the 2006 election, everybody said, oh, there's going to be a backlash against the Democrats. Well, I'll take that kind of backlash any time. I mean, here we took over the Congress. So I think that that is an argument of fear that we have been sort of scared into by some other political results that have occurred. But I've always been a believer that the best defense is a good offense, and you move forward. You set the agenda, you frame it the right way, and ultimately good policy is good politics.
Well, yeah.
And I believe that.
Right.
And I just think that, you know, that's the way to frame it. And with respect to the first, in terms of, you know, what's the proper role of statement? Well, you can make the same argument for the national level as well. The same thing happens if we're focusing on Congress and its ability. You know, sometimes Republicans are controlled, sometimes the Democrats are, sometimes conservatives, sometimes liberals. I mean, that's just the nature of the political process and the political game.
Mark, and then Rita, did you have a jump to?
Yeah, do the right thing. I'm sorry, first of all, follow the rules. Do your job, the job you actually have. And do what you do within the context of that job. And don't try to do as the AG in Kansas did, try to reach beyond the parameters of your job and start legislating from the AG's office. But within that context, secondly, and I think I understand my civil procedure professors here, cross your T's and dot your I's. I mean, do it right, do it well, and deliver a product that is legally sound, at least from a law office perspective. And I presume you want to do legally sound things in the legislature, although ours doesn't always do that. And I'm now defending the statutes that I argued vigorously on the floor were unconstitutional. So it's always a lot of fun. And then if you do the right thing, then your philosophy and your background and what brought you to government and politics will then shine through. And then the opportunity comes. And it's frustrating sometimes because, I want to do what is my policy objective 100% of the time, and that's not what I was elected to do. I was elected to defend and enforce the laws of the state of Ohio. But if you look within the context of that frame, and I think you've done a good job of that in Cincinnati as well, you can move a policy agenda forward. So don't get ahead of your job. Don't get ahead of the public. But in that context, I mean, this is where the action is in moving the agenda forward, improving the quality of people's lives, and improving the ability of people who are working class and poor to advance their economic agenda to get jobs and to improve their lives. It's happening in the state and local governments. And frankly, at the end of the day, the federal government is so stalemated, I don't think it's ever going to happen there, at least not for a long time.
Rita, did you want to jump in?
I think that there are still some checks and balances, and I think a lot of those checks and balances belong to the people. Most interestingly, in Cincinnati, the county decided that they wanted to build a new jail. And they decided they were going to build a new jail without they put the sales tax on the ballot last election. It failed. They decided this time they were going to build a new jail but not put the sales tax on the ballot. And the people stood up. And the people got enough signatures and petitions out, and they filed the signatures to say, no, you're not going to be able to do this. You're not going to be able to build the jail on our backs by increasing the sales tax without letting us have a say. And as a consequence, it will be on the ballot in November. The people took control of the process because they did not agree. Or similarly, when there is wrong, also Cincinnati being very special, we had sexual orientation being precluded specifically as a protected class. And we actually had it in our charter. There was language to that effect. And we actually had on the ballot a charter amendment that said, we need to remove this, that this is horrible, this is horrific, this is antiquated, whatever you want to call it, and that there needs to be a statement that we are no longer this rigid and this conservative as a community. And so the people took control and decided to pass something that said, we need to remove this language that seems to come from prehistoric times and say that it cannot be a protected class. So even if you move too far out there is a check and a balance, whether it's in the courts by filing some action. You may not always be successful, but at the end you can always get something on the ballot that the people really stand up and take control.
Okay, Raj and then Jamie.
If I could just slightly disagree with Dennis here, there is a backlash, and it may not be in the states that you mentioned, but there is no doubt, particularly on the issue that you were talking about, that it is manipulated by the other side in an extreme way, and to deny that, just is not the reality we face when we're on the trail. At the same time, to get back to your first question, so be it. That's the political process. You're moving forward in the ways that you can, and with the confidence of your public. And if that's the case, then it's our job in places where we have to experience some of that backlash to get out there and fight hard and defend progressive principles. The thing that I experienced the most over the last 20 years in terms of the movement structure has been the starvation sort of the farm team at the local and county level. And so those sorts of those backlashes can be much easier absorbed and hopefully eliminated in the future if we can start winning back at the state and local and county level and start restocking so that we're not so fearful. The reason why it's a backlash is because it works, because we have no counter response. So, slight disagreement, but I think on the core point, let the states and localities innovate, because they are, in terms of the question about agenda setting, I'd rather we be agenda setting at that level, frankly, than at the federal government from certainly what I've seen in recent history.
Jamie?
Yep, I think I'm with Raj on this. On question 1A, it amuses me to think that right-wingers needed the example of progressives to know that they could use local and state power to oppress people. If you think about the segregation that took place, the discrimination that took place in all these cities and states and counties, most of that came first. And I don't think any of us are taking the position that states, counties, and cities and municipalities should be exempt from overarching Bill of Rights strictures and constitutional scrutiny. I mean, if we do anything that violates people's constitutional rights, by all means, strike it down and let's fight about what the Constitution means. So, I don't think we're taking the position that, localism uber alles. In fact, I would make the argument that there's nobody in America, including professors of local and state government law, who really believes in federalism as an abstract proposition. I mean, I think that the people here at this conference really believe in a set of ideals and a set of principles that animate our politics, broadly speaking, in terms of justice and equal treatment and freedom and solidarity in society. And if we can make that happen at the national level, if we could have universal health care at the national level, great. But we can't. But we can make it happen at the state level, en route to a society that makes it possible for everybody. So, the right-wingers, they will go national if they think that that's how they can stop tort reform in the states. They will go local if they think that that's how they can pass anti-gay legislation. They don't get hung up on federalism. They turn it on and off according to their strategic maneuvering. And, I'm not saying that we have to be, so unprincipled, but I do think that we're part of a movement that's trying to push a set of values. And again, within the system of federalism, there are different places that make sense at different times.
And I think the question, just to add one note, presupposes that we have a choice to license cities and states. We're here. And if progressives and people with an agenda that you agree with don't occupy them, then somebody else will.
So I'm going to ask another two-part question. And it's not just because I'm an academic that I'm disguising two questions into one. It's actually I'm trying to sort of pull together the questions from the audience. So there's two other themes that run through these questions. One is, what is the biggest obstacle to getting your job done? So is it a question of federal preemption? Is that your problem? Is the problem resources at the local level? So what is it that's making your job hard right now? And then the second question is, imagine we could lift those obstacles. And so imagine that, there's no difference right now in the world between pursuing progressive causes through the local level or the national level. Ceteris paribus, since Jamie's going to quote Latin, do Latin, I might as well as well. So if you can go through the local state level versus the national level, which is better? Are they just absolutely the same? So one person in the audience worried that all of this focus on localism is actually distracting us from focusing on the national agenda, and that it's all very nice for places like San Francisco, but we're leaving folks in Kansas in a bad place. Or is it that you actually think you can build a national movement from the local level? So I'll open it up to all of you for that on that one.
I think there's a really dangerous trend in federalism right now that this decommissioning of of the regulatory structure in this country. I mean, there's a case in the U.S. Supreme Court now. New York is working on an amicus brief on it, which says that if the FDA says that a medical device is safe, then no state court should be allowed to challenge that finding. We have the SEC siding with corporate management over investors. We have a U.S. Justice Department that has never seen a merger that it doesn't want to approve. And maybe they'll negotiate a little bit, and maybe they'll put some lipstick on the pig, but they're not at all addressing the issue of competitiveness in the competitive environment. And that preemption, and they're fighting for that preemption in court every day. So I think that's the greatest obstacle at the local level, that you'll end up with these preempted regulatory structures at a very minimum. And in Ohio, the state did that. The state did it with predatory lending. With payday lending, and with predatory lending too, for that matter. Before I was in the legislature, fortunately, because we passed a real good bill when I was in the legislature, and Mike Deemer's here who worked on it with me. So we have a great, probably the best predatory lending legislation in the country now. But 5 years before that, the state passed a bill when Cincinnati and Cleveland passed their own predatory lending laws that preempted that and put in place such minimum standards as to make it virtually free reign. And in fact, we had free reign in Ohio, resulting in the highest foreclosure rate in the country in 2004 and 2005 and 2006, forcing us then to revisit the issue at the state level and close the circle and then actually do the right thing. But at the federal level, it's that kind of preemption that's threatening our ability at the local level to do our job every single day.
I think for me, it's not a federal versus state or local question. It's a law versus policy question. I think that's probably distinct for those of us who are in legal roles rather than in legislative roles. But so many of the difficult issues we face in the district, violence, our schools, the big complex social issues that most of our urban jurisdictions are wrestling with, can't be solved by the tools I have. So, we can do all we can to get guns off the street, but I don't have the ability to deal with the issues that push people to violence, poverty, family disintegration, all of those issues. And I think that on a day-to-day basis, that's probably what we struggle with most.
I would say it's probably for us a combination. It is preemption as much as it is resources. Resources are diminishing rapidly for the municipalities and local jurisdictions. But simultaneously, we're also getting mandates without support to do it. And we're also being precluded from having the ability to protect our communities. But to your second part of your question, you asked, do we have to choose one or the other? And I really believe that we don't, that the success exists in our ability to find that commonality. I often say when I'm trying to sell or negotiate a settlement, you have to choose a common goal, a common vision. And then you figure out, I may want to sing this tune, but the other side may want to sing another, but somehow or another we're going to get to that common vision. We don't have to choose one or the other, but we have to figure out how we can work collectively. And I think that the states and the counties and the cities have an ability to do things that can't be done on the federal level or on the national level, but can help support the agenda or bring the people and make them involved and engaged in the process. And once you bring the people involved and engaged in the process, then you start to set the agenda on the national level because they have to speak back. They have to respond. But the ability, that the obstacles exist first in that mandate that comes down that we need to stop that message. And then we need to have some resources so that we can empower our communities to grow and prosper.
So we have time for one more question since we have about 5 minutes left. And so I want to ask you, each of you, to say a little bit about, give a little bit of advice to the young lawyers and students in the audience. And I want you to do so for this reason. When I left law school and someone said to me, well, what are states for? I started scratching my head and said, I don't know, state birds and flags? I mean, what are they for? And so, I had that sort of typical bias about looking towards the national as any other law student. And I see this very much in my own students. They're all in Washington, and they're all in this audience. But they're in D.C. for a reason. Very few of them think to go to localities, to state or city government, to do the kind of work they want to do in pursuing a progressive vision. And I find this particularly upsetting because in the last year, actually because of Dennis Herrera. The city of San Francisco has started a connection with the Yale Law School in Berkeley and letting students take part in the work his office is doing in pursuing affirmative litigation on behalf of progressive causes. And I've watched these students have what has to be one of the best experiences that they've had in law school because they're getting to do something, not just sort of think about what they'd like to do, but file a complaint. And so it's a remarkable moment, I think, for them because the city is different from any other public interest group, and in that it's able to do things that other public interest groups don't. So I wonder if you might just sort of give one last piece of advice to the younger members of the audience, or the older members who are sick of their jobs, as to thinking about state and local government.
You know, I can tell you just in the short time I've been Attorney General, we've had an influx of Washington lawyers come to work in our office. Bill, I think, has helped inspire a lot of that, and I very much appreciate that. But the fact is that the only action, in fact, when I registered, the young woman that signed me in told me that she was a law student in Oregon, and she worked for the Department of the DOJ, is what, Department of Justice. And I said, well, that's interesting. And we talked a little bit, and finally realized it was the State Department of Justice, the State Attorney General's office, where she worked, because it is the best place in the country. Any of the 50 AG's offices, even the Republican AG's offices in this country, are bringing innovative cases, changing and improving the quality of people's lives every day in small ways and in large ways. We had, in the last AG's term, 6 cases in the U.S. Supreme Court. We've already had one, of course, Bill persuaded Clarence Thomas, which was just incredible, on our behalf. But sometimes you're on the cases aren't always. I mean, you still have to represent your clients, and you have a job to do, and so it's not all. Everything is not all a liberal fantasy. But the fact is that you can make changes, not incrementally, but very substantially, and even by bringing cases that you lose. Even by bringing cases that you lose, you can change the direction of public policy and change the behavior of people who are bringing harm economically or environmentally or through the antitrust laws or through civil rights. Because if you make it harder to do that, you've done something really meaningful. And so it is, I think, the best place in the world. I worked in an AG's office right out of law school, and I can tell you that it was life-changing for me, and I hope hope some of you give it some consideration.
Let's see. I've got a couple pieces of advice. One is fall out of love with the Supreme Court, which is, still riding on its brief heyday around Brown versus Board, and a decade or two after that. For the vast majority of its history, the Supreme Court's been a profoundly reactionary and conservative institution in American life, and has just returned to its original baseline. Think legislatively as much as you think judicially, because that's really how you can get stuff done, and go into the states and localities. I have a seminar in the spring, a legislation seminar, and we meet on Mondays. I bring my students up to Annapolis for the rest of the week, and they work for me or other senators. And our staffs are tiny. We have, 2 or 3 people. If, the ones who work on Capitol Hill, they're in a staff of 70 or 80 or 90. They come to the state capitol. They're writing bills. They're writing amendments. They're in on all the meetings. They can actually get stuff passed and get stuff done right away in the course of 3 months. And you can have that kind of extraordinary impact. So, resist the allure of Washington, not categorically, because there might be right places to go for some people, but there are lots of other opportunities out there, and we need you.
Well, let me just say, there is a Washington that isn't a federal city. So when Jamie says to resist it, remember, we have this vibrant town here that has lots of other things going on. I'll just tell a quick story. When I started at Legal Aid, where I was a public defender, I was working late, one of my first months on the job, preparing for some trial the next day, and a mouse ran across my desk, and I'd like to say I was calm about it. I went back to work. I fled, in fact. And I called downstairs to security and said, I've got a mouse in my office. What can you all do? And the guy said, no problem. We'll be right up. And he came up about 10 minutes later with 2 cats. And the fun thing about being in local government is you've got 2 cats, but you can be enormously creative. It requires you to be creative, resourceful, strategic. I think you've got to be smarter and better at what you do when you're working with what you've got. So it is the most fabulous place I've ever worked.
people often say to me, I've done private sector, public sector, so I've done the law firm experience, and I've spent a great deal of time in public sector, and people often say to me, what's the big difference? What do you notice? And so I kind of simplify it to an analogy. Imagine a pie, and imagine that you are instrumental in some portion of the pie. Well, if you're in the private sector, you only have one small portion of the pie. You're either putting on the top or you're doing the foundation. Imagine a key lime pie, which is my favorite, and you're doing the graham cracker crust, and that's all you're doing. But if you're in the public sector, that pie is yours. And either it tastes good or it doesn't, and that's either on you or you're either stuck with it. So the reality is, what do you want to be? Do you want to be just a piece of the pie, or do you want to have the entire pie? Sometimes the benefits have burdens, because with responsibility, you also have to accept the responsibility if things go bad. But also, I'm not putting down the firm experience, because it's also a learning curve. But the greatest thing about the public sector is you get to do trials, you get to do depositions, you get to share in the victory of your successes, but you also get to learn from your losses. You get to be instrumental in policy. I get to drive around the city and say, I was part of that, I made that happen. And there's something very satisfying about saying, I was piece of making a difference. So for every place that I go, I always say, I hope I left it a better place than I found it. And in the public sector, you will get a real sense of satisfaction in saying, I left this a better place than I found it.
I've had the opportunity to serve in the private sector and then serve in the federal government and to do what I do now. I was all through law school. I worked in the office of the legal advisor at the State Department, and then during the Clinton administration, I was there for 2.5 years. And I knew that when I went to the Clinton administration, since I was at that point in escrow on a house I was going to buy, and I had to make a conscious decision: what am I going to do? Am I going to move to Washington, or am I going to come here? And so I went through on the purchase of the house, and I went to Washington. I used to come home to San Francisco every 6 weeks. And the reason that I did that was, at least for me, I knew that I wanted to go home and make a difference in my community in a hands-on and concrete way. So I don't need to discount to anybody the virtues of being involved in federal service here in Washington. But there are a lot of things to do. And here we are mainly talking about in the legal or political realm. But there's nonprofit work in your community. There's things that you can do. And there are a lot of ways to make a difference. And I can say that for me, it's the right choice for me to be in San Francisco. And there's nothing that's more rewarding to me than to see something that I really played a role in to be done. We just recently opened a new Boys and Girls Clubhouse as a result of a settlement that we reached in the most neglected area of San Francisco. I tell everybody, same-sex marriage, late-term abortion, you put all the most rewarding thing that I've done as city attorney is get that clubhouse open and see smiles on kids' faces who didn't have any opportunity and didn't have anything. So there are a lot of options there, and if you really want to make a difference in your community and you value that hands-on sense of accomplishment, doing work in your community and getting involved, regardless of it, is just as noble as being involved in service here in Washington.
Right. Obviously, I agree with everything, and you know where I am on this. We badly need you in as I said, red states, but in any states and localities. 3 quick points that just like glosses on what I've heard. One is that you don't have to choose one or the other right out of law school or early in your career. I'm an example. I spent several years here, did great work, but then moved back and love it and there to stay. Jamie, worked in national level stuff for a couple decades, without revealing your age, Jamie, before he actually went back and ran. The second point is, and to those of you, I think all of you, if you're here, you might have a little bit of ambition firing in you. I know you're not supposed to say that. States and localities are smaller ponds. You can rise quicker. You can do things. You can get your hands dirtier so much more immediately with all the great examples that my colleague said. In fact, I had my law clerk. It was funny, Jamie said that the staffs, he was complaining about 2 or 3. I have 0 staff. And so we really have, when I said we don't read, we don't read. And so I had a law clerk from KU Law School. I am proud to be the author of a funeral picketing law that restricts Fred Phelps and other people from picketing at the funerals of people who've died in line of duty. My third-year law clerk wrote that bill, and I'm unabashed about saying that. I reviewed the research. I did a lot of the politicking. I'm aware of every comma in the bill, but she did the bulk of the research. She sent me an email. She's she's actually a Republican, and she said, this is the greatest experience I've had. I didn't know law could come alive like this. And that's because she just, it was a normal legislative internship, and we got a law built into law. She knows the governor now, and it's great. So the ability to rise quickly can happen at the state and local level. As we know, things may not actually go at the most rapid level here in the Beltway. So come home, we need you.
So before we end, I'm instructed in my best flight attendant voice to say the breakout sessions immediately follow this program are detainee treatment under the Military Commissions Act, immigration adjudication under stress, the Establishment Clause in standing, injury and enforcement, and the search for compromise and consensus on reproductive rights. But before we do that, I would like to just thank the panelists for talking about cats and mice and steamrollers and key lime pie.